What are the unique challenges with commercial vehicle accidents in Pennsylvania? A commercial vehicle crash can become far more complex than a typical collision because several parties may share legal responsibility. The unique challenges usually come from the size of the vehicles, the seriousness of the injuries, the number of potentially liable parties, and the federal and state rules that may apply. A fully loaded tractor-trailer can weigh up to 80,000 pounds, which often means more severe harm than a crash involving a passenger car. Unlike an ordinary car accident, these claims may involve the driver, the trucking company, the cargo loader, a maintenance provider, a vehicle manufacturer, and multiple insurance carriers. That makes liability harder to sort out and can make the claims process much more demanding. Federal motor carrier safety regulations may also apply to commercial carriers operating in Pennsylvania. Those rules address driver qualifications, hours of service, vehicle inspection and maintenance, and cargo securement. If a driver was speeding, distracted, impaired, or violating hours of service requirements, that driver may be liable for the crash. If the company failed to train the driver properly, maintain the vehicle, or pressured the driver to exceed legal limits, the trucking company may also be responsible. Under Respondit Superior, an employer can be held liable for negligent acts committed within the scope of employment. Improperly loaded or unsecured cargo can shift during transit and cause rollovers or roadway hazards. When that happens, the party responsible for loading the cargo may be liable if securement standards were violated. Pennsylvania also follows a modified comparative negligence system under 42 Pascals, CS. Section 7102. That means an injured person may still recover compensation if their share of fault does not exceed 50%. If the injured person is found 51% or more at fault, they cannot recover damages. Any recovery is reduced by the injured person's percentage of fault. In these cases, the defense may argue that the injured driver was following too closely, failed to signal, or changed lanes unsafely. That is why early evidence preservation matters so much after a commercial vehicle accident. Black box data, driver logs, dispatch records, and maintenance files can help show what really happened. Compensation may include medical expenses, lost wages, reduced earning capacity, rehabilitation costs, and other out-of-pocket losses. A victim may also pursue pain and suffering, emotional distress, loss of enjoyment of life, and loss of consortium. If the crash is fatal, wrongful death and survival claims may allow recovery for funeral costs, lost future earnings, and pre-death pain and suffering. Property damage claims may also involve total loss value, diminished value, loss of use, and business interruption losses. After a crash, it is important to call 911, seek medical attention, document the scene, gather contact information, and avoid giving a recorded statement to the trucking company's insurer. A lawyer can help preserve critical evidence before it is altered, overridden, or destroyed. An attorney can also identify every potentially responsible party and deal with insurers that may try to limit or deny payment. Because commercial insurers often move quickly and these cases can involve complicated evidence and multiple policies, speaking with a lawyer and an attorney early can make a major difference. For guidance, contact the law firm Luxenberg, Garbett, Kelly & George PC at 724-658-8535, located at 315 North Mercer Street, Newcastle, Pennsylvania, 16101, United States, and remember that an experienced law firm can help protect your rights after a serious commercial vehicle accident.